Hi, I'm Elizabeth Gearhart. I'm sitting here with James Klobucar, Senior Associate at Gearhart Law, and also very good at doing trademarks.
Thank you.
James filed a trademark application for me. Then he came back to me later and said, there's an opposition to your trademark. And I'm like, what? How did that happen? What does that mean? So, James, what happens after you file the trademark application?
After you file an application, there's two main hurdles or two main thresholds that you have to overcome in order to get the trademark. And one is you have to take care of all the technical requirements before the eyes of the Patent Office, or Patent and Trademark Office, I should say. And once they've deemed that you've met all of those qualifications, they then publish the application for 30 days in a publication period. And that publication period gives any member of the public, that is any third party, 30 days to, comment publicly and try to oppose your mark if they think it would harm their business. They could also, if they so choose within that 30 days, let's say they need additional time to make a decision, they can file for an extension of time, to file that opposition as well. So if you've gotten an opposition on a trademark, what that means is there's some third party out there that believes that your mark will somehow materially harm their business or a mark that's used in conjunction with some sort of good or a service that they offer.
So then what happens? Do you fight for me and say, no, these people are wrong, she deserves this mark? I mean, what happens next?
Yeah, you have to take every case on a case-by-case basis and determine the merits, but an opposition is essentially, a court case. It follows, federal rules of civil procedure. There's discovery, you can take depositions, and all of this happens throughout a prolonged time period. The opposition, overall can go for, easily a couple years. Obviously, you want to get out of it as soon as you can. Most of them settle before a final decision by the Trademark Trial and Appeal Board. But that's, in a nutshell, what you're going to be looking at.
From the time I file the application to when the opposition can come, how long is that? Is that a month, 2 months?
Usually you're going to be looking at around, I'm going to say maybe 5 months, give or take. There's going to be some variance in there, but what happens is about 3 months after you file a trademark application, it's going to be assigned to an examining attorney who has to review it. If they send out an office action, they give you 6 months to respond to that office action. So if you take, that 6 months, obviously that's going to change the time frame. But going off the assumption that you respond in an expeditious manner or that you don't receive any office action at all, then they schedule it for publication, and once you have that publication date, it's for 30 days, and that normally take maybe a few weeks once all the issues have been taken care of. So right around 5 months, give or take.
So can I use it during this time?
Yeah, you can still use it. You should always review the merits of the opposition closely and determine if there is any infringement potentially by any party or what's really being alleged. You may decide that the risk is too great. You may want to, put use on the mark on hold to limit, damages and that sort of thing. But unless counsel, instructs you otherwise, generally both parties will continue to use the mark during that time frame.
But if you've done a trademark search, then hopefully this would have come up in the search.
Yeah, that would be, the idea. And in all likelihood, it may have. Obviously, if you get to the point of publication, the Trademark Office doesn't think that there's any issue, right? So you've passed that threshold because the Trademark Office does review your application in light of third-party federal registrations. It may be that someone has, an unregistered use, which again, in all likelihood we should have found in the search and already be aware of and counseled you on. Or at the end of the day, people are subjective. They can form their own opinions. If they think that something is too similar, trademarks are if you don't use it, you lose it type thing. So you do have to actively police, the mark. And some members of the public or, even corporations will employ, watch services to watch over the trademark gazettes and the publications and basically will file an opposition or an extension at least and engage you at that level. If anything is even remotely close. At times it may be much ado about nothing and may be able to dispatch it pretty easily. Other times it's going to be, much more nuanced. It'll just kind of depend.
So the sequence is you file the trademark application, you go through all this stuff with the trademark office, and they say, okay, well, we think you can have the trademark, but we're going to make sure that nobody else wants to fight you on it. And so then they publish it, and then somebody can do a trademark opposition. So so the trademark office thinks you should have it, but somebody else can say, I don't think they should have it.
Right. Then eventually, if you progress far enough, the Trademark Trial and Appeal Board will render a decision in who's correct or not.
So then what if they say you can have it and this other person was wrong?
At that point, then, they would have issued, a decision, or you reached a settlement, to that respect. You should be allowed to proceed to registration at that time, and they're not going to be able to come back.
Does that cost a lot? Do you have to pay legal fees?
For an opposition?
Yeah.
Yeah, I mean, oppositions, as I said before, can go on for some amount of time.
Right.
You have discovery, you have briefs, you have, potentially depositions and all of those good things that come along with that. So you can certainly, spend a fair amount. Obviously, it's going to depend a little bit how far through the process that you go. Through some initial discovery, depending on how complex it is, I mean, you could easily spend $25,000 plus.
So I should probably balance at that point then. So let's say I started using my trademark for a couple months, got my first sale so that I could register it as a trademark in use across state lines or whatever. I did an internet sale.
Mm-hmm.
And then 6 months later, so it's been like maybe 8 months for me, I get this opposition. And so then I have to weigh how much marketing have I done? How much branding have I done with this name versus fighting the opposition with legal fees, right?
Right. You have to weigh the pros and the cons and your investment versus the budget versus, the brand power that the mark holds. And rebranding has to be, part of that as well in terms of, your considerations.
So could you rebrand just a little bit? Maybe sometimes it would work like instead of like fuzzy babies, fuzzy infants, and they'll say, okay, well, fuzzy infants is far enough away from our fuzzy babies.
Yeah,
So sometimes that works.
Yeah, it could. It's going to depend a little bit on, the third party that you're dealing with, the other types of marks potentially on the trademark register. If you can reach a reasonable resolution with them on something like that, then certainly you're entitled to do so.
Okay, so sometimes you might have to change it, but maybe you could not have to change it so much that it's unrecognizable, right?
Right. I mean, yeah, again, it's going to depend on what mark the other party has or believes that is in conflict with yours. But yeah, absolutely. At times you may be able to preserve some portion of the mark.
So you really do, if you get a trademark opposition, you really do need to be working with an attorney. And you need to look at these different avenues about settling, about slightly changing your mark, about dropping your mark altogether, or about fighting your way through to the finish, right?
Right. Yeah, I agree. I mean, process in and of itself is pretty technical. It's very deadline driven, and if you miss, deadlines, people can move for a default judgment in their favor, at which point you could be out of luck. Of course, you can then put in your own motion in opposition to the default, etc. But again, it's going to help to have an attorney help lead the way through it. Outside of that, it's going to be very difficult to handle.
So trademarks aren't as easy as they should be, or like they seem to be. Like you can't just file a trademark application and get your trademark and go on your merry way. If you're really serious about your business, you do want to hire a trademark attorney to help you do the search, try to keep you out of hot water, oppositions, those kind of things, and then help you the rest of the way if anything happens. So this is the guy to call.
I agree.
This is James Klobucar. You can reach him at James at Gearhart Law.
Yeah, just give me a call if you have any questions, and I'll be happy to assist you with your trademark.